This matter concerns the defendant, Michael Jones, who is charged in Harris County, Texas, with the offense of interference with the duties of a public servant. The charge arose from an encounter between the defendant and responding police officers on January 10, 2025. According to the sworn narrative read in court, officers in official uniform and operating a marked patrol vehicle were dispatched to a reported disturbance at a residential address. Upon arrival, officers observed the defendant outside the residence, while a resident instructed him to leave the property. The defendant allegedly refused the resident's request and verbally engaged in loud and aggressive behavior. Officers identified themselves and approached. The defendant then began to walk away. Police issued verbal commands directing him to place his hands behind his back. The report asserts that he refused compliance, pulled away, and physically resisted attempts to detain him, resulting in a ground struggle before handcuffing efforts continued. The offense carried a potential penalty of up to 6 months in jail and/or a $2,000 fine. Defense counsel formally challenged probable cause, prompting the court to conduct a preliminary hearing to determine whether the case should proceed.
All day long. But hey,
So-
I'm the popo.
Let me come and mess with you more. Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and/or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away.
At the outset of the hearing, the court addressed the defendant directly and explained that counsel intended to contest probable cause. The prosecution read the officer's sworn statement describing the disturbance call, the resident's demand that the defendant leave, and the defendant's alleged refusal and aggressive conduct. The statement further alleged that after officers announced themselves and gave commands, the defendant failed to comply, resisted, and physically interfered with detention efforts. Defense counsel immediately questioned the legal basis for the stop and detention. Counsel emphasized that once officers arrived, the defendant began walking away from the property, which counsel characterized as compliance with the resident's demand to leave. The defense argued that mere yelling, emotional behavior, or profanity does not constitute a crime, and that walking away from police, absent lawful detention or arrest, is permitted conduct. Counsel also challenged the mention of possible intoxication, asserting there were no specific facts establishing reasonable suspicion. The defense contended that officers retroactively justified detention after disliking the defendant's departure. Accordingly, counsel maintained that any subsequent resistance could not support an interference charge because the initial detention itself lacked lawful grounds. Therefore, all later evidence should be excluded as derivative of an unlawful stop.
The defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No. Just
Losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location being told to leave, and they observed him verbally refuse. And then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, hey, I'm the police. You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass
The debate then
investigation.
focused on whether officers possessed reasonable suspicion to continue investigating after the defendant began leaving the scene. The court questioned whether the original disturbance call effectively became a trespass investigation and, if so, whether the defendant's act of departing terminated any basis for further detention. The defense argued that once a person leaves a property at the resident's request, the suspected trespass ends, thereby eliminating grounds for police interference. Counsel maintained that officers cannot command an individual to stop solely because they announce themselves as police. The prosecution countered that officers still had authority to investigate the disturbance and determine whether a trespass had already occurred. The state asserted that the defendant left only after police arrival, suggesting potential avoidance of apprehension. Prosecutors further argued that signs possibly consistent with public intoxication provided additional justification for continued investigation. Defense counsel reiterated that no specific, articulable facts supported intoxication and that the officers' actions escalated a situation that was otherwise resolving. The central legal issue became whether any lawful detention existed prior to the alleged resistance, as interference with public duties requires a lawful exercise of police authority.
Trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only.
Right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be. it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
Thank you. Hear what happened? Thanks.
After hearing argument from both sides, the court evaluated whether the officer's observations established probable cause or reasonable suspicion sufficient to justify detention and support the interference charge. The judge expressed skepticism that continued police engagement was warranted once the defendant began leaving the location. The court noted that if the disturbance or potential trespass ceased when the defendant departed, the legal basis for further detention weakened significantly. Finding the defense's arguments persuasive, the judge concluded that the record did not sufficiently demonstrate probable cause. Specifically, the court determined that the facts presented failed to show a lawful detention preceding the alleged resistance. Without a lawful detention, the statutory elements necessary to sustain an interference with the duties of a public servant charge could not be satisfied. Accordingly, the court announced a finding of no probable cause. As a result, the case did not proceed forward. The defendant was released without bond conditions or penalties imposed at that time. The judge admonished the defendant to avoid future confrontations and exercise caution in his conduct. The proceeding concluded with the charge effectively dismissed at the preliminary stage and the defendant discharged from further court action on this matter.